I am Emilio de Capitani, a former secretary of the Civil Liberties Committee, a parliamentary committee who fought for years to have a more clear legal framework for data protection, notably when security issues are at stake. And I am more than happy to co-chair this meeting with my colleague Diana Alonso Blas, who is the head of the Data Protection Service and Data Protection Officer in EUROJUST. We will try to deal with 4 different issues. So the speaker will have a very short period to intervene. The issues that we propose to deal with are, first, the scope of application of the draft directive, obviously after a general, very short description of the content of this draft. So scope of application of the draft directive, then the rights of the data subject, and then transfer. If we have time, we will deal also with a very sensitive issue, which is the transfer to third countries. So I ask Diana to introduce briefly the description of the measure that we are discussing, and then...
Okay. Thank you very much, Emilio. Well, this panel is indeed about the draft directive, which is part of this package we were already discussing this morning. There is the reform package of the European Commission, and there you have the regulation, which was discussed in the first panel. And we have this draft directive, which would apply in the sector of police and justice, the whole law enforcement sector. And this directive has been, from the beginning, a very controversial instrument for various reasons. It has been criticized from both sides. One could say it has been criticized as not being sufficiently ambitious, and people have said it doesn't go far enough. This is a very difficult area where the data subjects are very much exposed. We need to go farther. On the other hand, we have some member states saying, well, the European Commission is going too far into the national competencies. The area of police and justice is linked to criminal law, which remains still a national field, and therefore the Commission is stepping too far into the national area. At the same time, the instrument has been criticized sometimes for the mere fact of being there. I mean, we have people who consider that we should not have 2 different instruments, but just one covering everything. And some who consider that even if we have 2 instruments, it shouldn't be a directive because this leaves too much space to the member states. But again, the other side of the coin are those who think, well, it is a great idea that you have a separate instrument because this is a sector that has different problems and very specific difficulties, and there I would refer to Declaration 21 of the Treaty of the European Union, where it says, Treaty of Lisbon, that in this area specific problems exist and specific rules are necessary. And also as to the issue of the directive, there are those who say, well, it is good it is a directive because the member states have always operated with unanimity in this area, and now we are making already a big step forward, but we should leave them some little space to still define how do these obligations have to be defined in practice. So there are pros and cons on the various areas, and I think it's very important to be reminded at the beginning of this discussion that here we're in an area in which so far at the EU level we only have a framework decision which is very limited in the scope of application and only applies to the international exchange of information but not to the national processing areas. So one could say that even if weak, this directive would be a big step forward. So, as Emilio said, we are going to enter into 4 different areas, but I think it would be good to start by giving the panelists a short time to give a general comment on the instrument as such.
2 minutes. So, let's start with maybe Peter Michael. 2 minutes.
Thank you very much. I will keep it in 2 minutes. The first remark is that the level of data protection is unfortunately much lower than the level of data protection you will find in most member states in the European Union in the area of law enforcement, and that is of course a worrying situation. might also be caused by the fact that the Commission never really evaluated the existing instrument, namely the implementation of the framework decision. They only counted how many member states did do an implementation, but not how or what were the experience. And that's, of course, a chance they missed. Another remark would be that the proposal aims to, apart from data protection, to enhance the cooperation between law enforcement authorities and to create mutual trust. But if you want to do that, you should have what I would call a tailor-made instrument. You could say on one hand that creating a directive is an instrument to allow to make a tailor-made provision for data protection area and law enforcement. But then if you really read the instrument, you can see that the only thing it does is missing real chances to come with a good level of data protection throughout the area and law enforcement. For example, if you compare the directive with the framework decision, you can see that the framework decision obliges law enforcement authorities to take actions when they have distributed data and they found out that it was either unlawful or the data was not correct. Such an obligation you will not find anymore in the new directive. And if there's one instrument in favor of data protection, enforcing law enforcement controllers to actively take care of data protection, it's that. Unfortunately, again, the directive doesn't say anything about it. Another missed chance is that the directive really doesn't protect what I would call the non-suspects. The evolution of crime methods creates far more the request from law enforcement authorities to create huge storages of data on non-suspects. And the only sentence in the directive says that member states should deal with setting up specific rules for other persons than suspect witnesses, contacts and associates. But that doesn't say anything. That doesn't really protect. There should be far more. You should use that chance to create a regime, let's say, not allowing to process those data and creating an example that in specific cases, under specific conditions, that should be done. I see that my time is up to 2 minutes. I will stop. 2 minutes, sir. Okay, thank you.
Now I pass the floor to Andreas Krisch.
Thank you very much. Well, even so the proposed directive takes some steps to improve certain aspects of the current framework and also would cover domestic processings, we think the proposed rules are too weak in many aspects. Data subjects' rights are, in our view, unduly restricted. For example, when being informed about profiling measures, data subjects do not have a right to be informed about the logic behind the processing and the profiling, to name only one. I will talk about data subjects' rights later a bit. Obligations of controllers are too limited in our view, and also data protection authorities do not have all necessary powers that they require to perform the duties. This is due to the fact that member states have the possibility to grant them less powers under the proposed than under the proposed regulation, which we think is not acceptable given the serious consequences, especially in the sector of law enforcement and data processing by law enforcement authorities. Data protection authorities should, in any case, have the same set of powers as under the regulation in our point of view. Specific rules on the relation with controllers in the private sector are missing. I think of the data retention, for example, where private data processors are processing the data that will later be used by law enforcement agencies. And we are missing regulations on how this relationship between the controllers from the private sector and law enforcement agencies to be dealt with, and also safeguards for data transfers to third countries are insufficient in our point of view. Transition periods for adapting the current legislation, 2 years or even 5 years, are too long in our point of view, which would delay the implementation and it will lead, Mr. Buttarelli said before, until 2020, until everything is in place, and with the directive it may even take longer to have all these rules into force. So we think we need a very short implementation period, and these things need to be reduced. So to sum it up, we think it's more or less a missed opportunity. Some things are better than with the framework, but it's not the big thing that we all were hoping for.
So, Karsten.
Yeah, thank you for the invitation first. Assuming that you all know about the directive and that much is shared on the panel anyways, I would like to make two remarks about things where the directive is not very clear as we find, and I hope also that that will prompt some discussion because it might be more controversial. These 2 points are, and I talk about them in order to promote the directive, is first harmonization and second differentiation. What do I mean with harmonization? It's rather unclear to us at least what level of, what degree of harmonization the Commission actually aims at. And that is difficult because it also reduces the support. Maybe I say that as a German representative, from a country that has 30 years of constitutional jurisprudence, which has been rather progressive. So obviously we all want standards that are as high as possible. We think a way forward would be, let's say, this is not a maximum but a minimum only. That would, I think, give some support to the directive. The second point would be differentiation. Peter mentioned non-suspects, and all these issues are important. And then there's a provision in the directive which do distinguish between different data categories, victims, perpetrators, non-suspects, and all that. And then the Council always says, well, if it's an ongoing prosecution, we don't know, we can't, that's rubbish, how to differentiate. And I think that it's helpful simply to distinguish between different purposes. Are we talking about an ongoing prosecution, or are we talking about the storage of data for the prevention of future crime, where it certainly makes sense and many people would agree. And I think that would be helpful to promote the directive to do more differentiation. Thank you.
Very in time. So, Herke.
That allows me a bit more time, I suppose. We have to be very short and speak in Twitter language, as I have seen. The higher purpose in life is to get up there. I want to say hashtag CPDP 2013 that Kranenborg says that the law enforcement area as an EU policy is quite immature at the moment. It's logical, but we see some clear adolescent behavior. The nicest example maybe is the data retention directive, but you see the same here with the directive on data protection. But I would like to underline that data protection is not a law enforcement issue. That sounds a bit weird maybe. Of course it's hugely relevant for law enforcement, but it's not something which is owned by law enforcement. No, it stems from one single right, or maybe two. The right to privacy and the right to data protection. So in all EU policy areas, it's a general condition for the proper conduct of private persons, companies and public authorities in a true area of freedom, security and justice. That's the European angle. So if we look at the current framework or patchwork of rules, is it clear for citizens that it's one single right, that it all stems from the same basic principles? No, not at all. So you see what the Commission, the ambition of the Commission initially was to produce something, and the EDPS underlined that as well, to produce something which would be comprehensive, consistent and simplified. So actually the patchwork had to be rewritten. But in the end, we end up with a regulation and a directive, two instruments. And all the existing specific laws stay into place, stay alive, like in both previous pillar areas. So not only law enforcement specific documents, but also, for instance, the e-privacy directive and regulation 45 for the EU institutions. Okay, two instruments, we can live with it. It happened before, see the European Constitution, which ended up in two treaties. But then at least you should make sure that law enforcement rules assure an equal level of protection with the regulation. At least, I think Jan Albrecht already underlined, maybe there are even stricter rules needed for the directive. Okay. Yes, I finished with one substantive comment. So, do we think that's the case? No, not at all. It ensures a lower level of protection. What was wrong? Purpose limitation is a mess. The principle of accountability is diminished. There are weak conditions for transfers. there is a limitation of powers of DPAs, and the exchange between private and public parties is not clarified.
Okay, so now you have 2 minutes, Diana, to introduce the more specific issue of the scope of application of the draft directive, in particular as to the question of the national international processing operation.
Well, I will be even shorter than 2 minutes because I want to leave the time for the speakers mainly. But I think as to the scope of application, a lot of criticism have been also addressed to the Commission in that sense. Some of the criticisms were linked to the fact that certain existing instruments, and let's speak for instance about the rules applicable to Europol, EUROJUST and others, remain untouched. This was explained very clearly by the Commission, saying this is not an omission, this is a clear element due to the fact, first of all, that this is a directive, and a directive by definition can only be addressed to the Member States. So it cannot be addressed to European institutions and so forth. And secondly, and this is I think a very important element, I think one should not forget that the instruments in place applicable to EUROJUST, Europol and others have a much higher level of protection than what this proposed directive has. So it would certainly not be a good thing of having this directive applicable to that. But I would like to concentrate now on the scope of application link to the international and national dimension. As we know, the framework decision applies only to the international data flows, which of course in practice remains very difficult. How do you know if you are carrying an ongoing investigation or prosecution? How do you differentiate? How do you process the data which is national and the data which is international and so forth? So it creates a lot of difficulties. Now the scope of application has been broadened to the whole thing, the national and the international, so maybe the speakers want to comment on this point.
Peter?
Mr. Chairman, I will do it in less than 2 minutes, hoping that what I reserve in minutes I can use for another subject. I'm always surprised about this discussion. For a simple reason, all the Schengen states involved in the Schengen Convention and all the European member states involved with Europol could only be involved when they had applied data protection law, which is at least equal to the existing Convention 108 in the police recommendation. Otherwise, they were not allowed to participate. So there should already be a very harmonized level of data protection linked to one instrument. So the whole discussion for me is a little bit strange. It's probably more political influence than on reality, because they're already, to a certain degree, harmonized. And the other aspect is, if one of the major reasons for this, apart from data protection, is creating free flow of information in the area of law enforcement, creating mutual trust, you should have a harmonized set of rules. And more important, if you're going for free flow of information, there should be what I would call a free flow of data protection rights. They should always be the same. And so for me, it's in fact a non-discussion, only for political reasons. Thank you.
Thanks. Andrea? No, we follow the same.
Thank you. Well, we of course appreciate that also domestic processing will be covered by a European piece of legislation. However, we think that this improvement is mostly a formal one, because on the one hand the rules are less precise and offer less protection than the proposed regulation. As I said, data subject rights, obligations on controllers, competences of the supervisory authorities, and there would therefore be comparable rules across the EU, but very weak ones, and this is a problem. And there are two main points that I would like to stress, which are really creating problems. One is that member states tend to differently define the activities of their authorities. So what is part of law enforcement in one member state might be part of normal administrative proceedings in another member state. And for example, in customs, immigration, environmental affairs, and so on. So this would mean that data processings in one member state might be under the regulation, because it is administrative proceedings, and under the directive in another member state, which again creates unequal data protection standards in the member states. So it's very difficult to see where harmonization is here. And the second danger that that I see is that the rules with regard to domestic processing even could weaken existing data protection standards in some member states that already have very good data protection standards. So this might result in a lowering of data protection standards in some member states, which of course cannot be accepted. And therefore we think the Commission should provide an assessment on the harmonization effects of this legislative piece and do an evaluation how harmonization can be achieved in a better way. Thank you.
Thanks. In fact, don't forget that before 1st of December 2014, the former framework decision in third pillar should be Lisbonized. So the Commission probably has already started to check how this law is applied in the member states. Karsten?
I share some of the concerns that Andreas expressed. Still, I find that including domestic processing is a step forward, because that's actually what we have more than we had in the framework decision. So I think it's in principle something good, bearing in mind that there are some difficult and dangers even that we might talk about. And that's also, when we think about what's the aim and why do we have this directive, I think, or why should we have it, I think the reason really is to make sure that every processing by any policeman or policewoman in any country, in any member state, is regulated by an as high as possible level of data protection. And if you think that that's the goal of the directive, you need to include the domestic processing. And I think in that respect, it is really one of those, probably this step forward of this draft. But there are concerns that I've referred to earlier.
Herke?
Thank you. I'm afraid we're all a bit on the same side here, so no discussion. But I fully agree. I think including it is the most logical thing to do. However, it should only be done if it actually raises the level of data protection and indeed does not lower the average, let's say. I fully agree with Peter that if you create, and that's an EU perspective, if you create an area of freedom, security and justice where people can move freely, where data is supposed to be exchanged and move freely, then you also need to regulate the other side of the coin, namely the protection part. So you have to have strong data protection rules. And of course there is a Convention 108 implemented in all member states, but also in the previous first pillar area there was a need for more specific, detailed requirements within the EU, Directive 95/46. So also here there is this need. There's no doubt, I think, that it should also cover domestic processing.
Thanks. So reference has been made several times to Convention 108. I hope that it will come again in the debate. Now, the second topic that we want to deal with is the rights of the data subject. Diana, 2 minutes.
Okay. Well, I think everybody understands that in the context of ongoing prosecutions and investigations by police and so forth, there are situations in which the rights of the individuals might not be fully exercised in a certain moment of time. Obviously, we understand that. However, the question is, are these limitations imposed to the rights of the data subjects adequate, legitimate, and also are they in compliance? If we go back, we were talking about the Council of Europe Convention, also to the jurisprudence of the European Court of Human Rights. Do we really fulfill all the requirements there? So the question to the speakers is, do you think that the limitations imposed are appropriate, and do they respond to these requirements, and at the same time are adequate to the specificities of ongoing investigations and prosecutions?
Peter?
Thank you, Mr. Chair. I will have one positive remark, which is the first of today. Then I will have something about the confusion caused by this instrument, the difficulties, and I have a negative remark. The positive remark is that the directive uses 7 articles dealing with the right of access, and the regulation deals with 8. But the regulation covers far more rights than dealt with in the directive, so you may assume there's a well-balanced system because it's used 7 articles. The positive thing is that it now regulates also the modalities for exercising rights and the obligation to inform data subjects by law enforcement authorities. But that at the same time creates confusion if you see the other articles. For example, you see there's a clear mix-up between what is data protection and what is typically law enforcement competence or criminal law issues, namely whether data is voluntary given or whether it was obligatory given. And if you introduce that, the first question I would ask is there a consequence if I voluntarily give information? If I voluntarily give my DNA for a specific investigation, can I, as a data subject, place a condition after that investigation should be deleted? Do I have that right? And that's the first question which confuses me if I see the words voluntary and obligatory. The difficult, I can go on for hours on this issue, but I won't in view of the very limited time. The difficult thing is that you have to inform data subjects that their data were processed, unless specific circumstances prevent that. But it doesn't say what are the specific circumstances, or that specific circumstances in the specific case for which the data originally were processed. And we all know that if it's processed, it will be kept processing, because once a criminal, always a criminal, according to the law enforcement philosophy. So what does it mean? And can you then say, well, if I process it in file A, I will always inform you, but I will never inform you about file B and C. But that's the core of data protection, that you know where it is in the transparency. And there's no answer in the directive. A negative point, I find that the directive allows member states to exclude categories of data for the right of access. I think that is not according to the jurisprudence. There should always be a case-by-case assessment. And in all the 25 years experience dealing with law enforcement and data protection, I never found one reason to exclude totally a category of information. And if you allow member states that, and if you want to achieve harmonization, you will give member states an instrument to exclude huge amounts of activities, law enforcement activities, from in fact data protection, at least from the core of data protection, the right of access for the data subject. So I'm very negative about that. I'm also negative about the possibility to move the data protection rights into the area of judicial proceedings. We all know judicial proceedings also have a sort of equality of arms system, allowing suspects to be informed. But I wonder if you would compare all those systems in the European Union, would you find a harmonized system in there? Would you will find in that system the same fundamental rights as we have in data protection? If so, there would not be a problem. But if there is no harmonization in that area, you should never exchange data protection rights, data suspect rights for rights they have in a criminal proceedings. And when you're a suspect in a criminal proceeding, you're at the same time still a data subject in the other proceedings. Thank you.
Okay, in fact, data protection is not everything. We have also to define a European model in criminal law and prevention of crime. So, one step at a time. Andreas?
Well, as you might already imagine, we think that a number of provisions should be amended to avoid excessive restrictions on data subject rights. For example, the regulation says that controllers are required to have policies on data processing and set up procedures to provide information, while the directive only says that controllers should take all reasonable steps to this end. So this aims, at of course, at limiting the responsibility of the controller, which is not justified in the directive, also in the special situation of law enforcement. The provisions on the reply of the controller should provide exact obligations of controller and the determined deadline for the reply, because waiting for months to get a reply on an information request is making data subject rights meaningless, more or less, because if I have to wait a year to get an answer, where's the point? A second point is that the possibility not to take a requested action or to charge fees if the request is vexatious. According to the directive, the regulation only says allows you to charge fees if a request is manifestly excessive. So Here again the question, why is there different language in these two pieces of legislation? It should be the same, and it should be the one of the regulation, only in the cases where it is manifestly excessive, fees should apply, and that's it. The level of protection should be comparable to the one foreseen by the regulation, of course. Another point is that the limitation of controllers' duty to provide information and subjects' rights to access may be restricted when restriction is necessary and proportionate. We of course appreciate the necessity and proportionality requirement. And additionally, the data categories may be defined that are wholly or partly exempt from this duty. We think that there is no justification for such a step to exclude a whole category, and therefore the articles of the directive should be amended, and any restriction must be in compliance with the Charter of Fundamental Rights of the European Union, with the Convention for Protection of Human Rights, and in line with case law of the Court of Justice and the European Court for Human Rights. Thank you.
Yeah, poor Herke is always the fourth, and I'm now the third, and I'm not even sure what I have to add to what my previous speakers have already said. The right of access in particular is one of the key fundamental rights. What we have been particularly critical of is that it has to be clear that if police or if law enforcement authorities don't have to answer, that request, it has to be regulated, and there have to be specific grounds on which they have to refer, and it needs to be, and that's really important, a case-by-case assessment. It needs to be an individual assessment, and that should be clarified in the text, as well as, and that I think as Peter already has referred to it, it has to be clear that the member states could not produce legislation that exempts whole parts from the right of access. That's simply something that should be deleted. Thank you.
Thanks. So, Herke.
Poor Herke takes the floor, hoping that there's something left to say. Maybe there is something. First of all, the EDPS has issued an elaborate opinion on both proposals. It was published on the 7th of March, and it can be found on the website, and we go through all the separate provisions of the directive. The right of access is maybe per se where indeed some specificity of rules might be needed for the law enforcement sector. I was not excluding that the law enforcement sector requires some specificities. This is maybe where it's actually justified. But then, and that's also something we stated in our opinion, that every departure of the general rules, so the rules in the regulation, should be duly justified based on a proper balance between the public interest in law enforcement and citizens' fundamental rights. So an issue like categorical exclusion of certain data or access rights should not be happening. Maybe one thing I could highlight is, well, two things. The limitations to the right of access are elaborated quite profoundly, but that's not the case with the limitations to the right to rectification or the right to erasure. That's a bit weird. It just says you have to be informed about a limitation. And maybe, and that's the thing which is really new maybe, the powers of the DPA. A DPA does not have the power to order access. Maybe this is sensitive, but why not? If you look at Article 46, which describes the powers of the DPA, there is no possibility to order the disclosure of the data to the data subject. That could be something which could really strengthen the position of the data subject.
Perfect, we are on track. Now we can deal with the third issue, which is the transfer. Do you think that it is adequate and well-suited regulation given the particularities of this sector? Peter.
Thank you, Mr. Chair. This is an issue on which I will be very careful to say something. According to the system in the directive, there is a list of states from the Commission will make a list of states which have an adequate level. There might be a list of states which are not compliant. If the Commission hasn't assessed them and there is a need to transfer data, the member state involved should check an adequacy level and create appropriate safeguards, legally binding instrument. And then the most important article probably, but that's the derogation. If it's necessary in a criminal investigation, you can exchange information. But trust me, that derogation will be the rule. Simply because that's the reason for which you're going to exchange information, to solve an investigation. And my other problem is that I never noticed that criminal organizations first seek which country has an adequacy level and then decide whether or not to operate from that country or not. So there's a sort of tension between what law enforcement needs and what we find important for the exchange of data in international transfers. And that is exactly also the reason why I think that the derogation, if the articles on certain states will stay the same, will probably be the rule. Thank you.
Thanks. It is in fact rather interesting to see that in the framework, in the draft directive, there is no comparable tool than the consistency mechanism which exists in the regulation, which is probably a rather shy attitude from the Commission side. So, Andreas.
Thank you. 3 points from my side on transfers to third countries. According to the proposed directive, the controller in the third country has to be a competent authority. I think we should clarify this point that in that way that transfers may only occur to public authorities competent for law enforcement purposes in the third countries and not to other recipients. Second, there is no provision on onward transfers. So these should only be allowed if necessary for the same specific reason that justified the original transfer, for example, the same case, and not for general law enforcement purposes. And the authority that carried out the original transfer should also authorize the onward transfer, so that it's always the same law enforcement authority that is taking the decision if the data can be transferred to another law enforcement agency as well. And the third and last point is on the adequacy decisions for third countries. We think that the Data Protection Board should have a say in this and should be consulted before issuing such adequacy decisions. Thank you.
Herke, it's up to you.
A change in order, I see.
Karsten.
Such a pity.
I'm wrong. Okay.
I was too short, I guess. You forgot me a lot. Anyway, I think transfers is a difficult topic, and also when we discussed the directive or the draft in the Beetle subgroup or in the Working Party 29 subgroup, we noticed that we have quite different rules that apply nationally. Sometimes transfers have to be approved by DPAs, sometimes DPA have to be consulted, sometimes DPA don't know anything about it and then afterwards might check it. And there are also different tastes on how to do that. I think the most disputed provision has been, do we want to allow member states to make a self-assessment and then based on that self-assessment transfer data? And that's something that we are very critical of. So if we talk about a systematic transfer of data, it should be backed by a legally binding an instrument, and that's one of those things that we've, I think, all agreed upon. Of course, there have to be individual cases where you need to transfer data if it's about a threat to life or something very serious, but that's what we have the exceptions for. But when we talk about systematic, I mean regular transfers, that should be done on a legally binding instrument. I think that's probably the most important issue that we have to discuss here. Thanks.
So, Herke.
Well, that's indeed exactly the point I would like to emphasize as well. Article 35(1)(b), where there is this self-assessment. But also the role, again, of the Data Protection Authority could be clearly strengthened. If you look at the text now, it says that the decision, the self-assessment about appropriate safeguards, must be made by duly authorized staff. These transfers must be documented and the documentation must be made available to the supervisory authority on request. But that can be much stronger. It should be at the same level as in the regulation. And furthermore, in the regulation there is a possibility for the DPA to suspend the transfer. That's not foreseen in the draft directive.
Okay, now we can pass to the fourth issue, which is the Article 60 related to the already existing agreements in this field, and probably also framework decision still into force. So, Diana, do you want to introduce this point?
Thank you. There we saw this morning Madame Levey started her intervention saying there have been a lot of people saying that we will have to amend thousands of agreements. This is not true. We will only have to amend those agreements who do not comply with the data protection standards, which I would say are most of the existing agreements. So in that sense, I disagree with her. I do agree, however, that there is a big importance in amending existing agreements. And let me tell you from my own perspective, EUROJUST, but also Europol and other EU institutions, we spent years negotiating with third countries and putting in place agreements for exchanging information with very high data protection standards. Agreements which indeed are quite good, but then what happens in practice? National authorities can still exchange directly the same information with the third countries on the basis of existing agreements at national level, which often have very weak data protection provisions, if any. But even more, what I have discovered during my own experience is that often these kind of exchanges simply take place on the basis of reciprocity. So there is not even an agreement. Simply authorities in law enforcement give information to each other. If you give me this, I give you that. And of course, I think one has to understand that in some cases this might be even a good thing to do if we are talking about preventing a terrorist attack or very extreme situations. But I think that we go back to the comment of Karsten saying, well, this cannot be the basis for systematic exchange of personal data. So what this Article 60 says now in the draft directive is that all existing amendments would need to be amended and put in line with the existing, well, with the new standards on data protection which are imposed. And interestingly enough, I had the pleasure of presencing the first discussion on this provision at the CATS working group in the Council. And I think it was the only point in which there was unanimity of the Member States against this provision. None of them want to renegotiate the agreements. I think it is understandable to some extent, because obviously it's a big workload. And also one element one should not underestimate is that, as they say, it takes two to tango. So maybe we need to renegotiate those agreements, but does the third party want to renegotiate this agreement, and does the third party want to agree to higher standards on data protection? So I do believe this is an extremely challenging article, most interesting. So let's see what our speakers have to say about it.
And don't forget that not only Europol and EUROJUST have agreements with third countries. We can make exchange personal data. Frontex is doing also, and other agencies. Many of these agreements are not public, which is not a very happy situation for citizens. Peter?
From a data protection point of view and the precision of the data subject, it would be the ideal situation that worldwide all states comply with the adequacy decision of the Commission, allowing European states and the European agency to exchange data with all states in the world. But let me give you an example. And don't forget, we already have a Convention 108 with a protocol dealing with third states. The organization I work for, it is the supervisory authority in Europol, is already consulted sometimes about the level of data protection in a certain very big state, very powerful and big state. And the conclusion was it's not adequate. Still, all European member states have a bilateral agreement with that state to exchange data in the area of law enforcement. That's a very strange organization. The European police organization is not allowed to exchange. All member states are, because they have a bilateral agreement. That's the reality. So where in principle there is an ideal situation, I will fully support it based on we have the fundamental rights of the data subject to protect. We also have to see the reality. And what if member states have bilateral agreements with the third state who will be put on the list from the Commission of not being adequate? Are they then forced to stop the agreement? I don't think member states will do that. So while supporting it, I think we should far more invest in discuss on the reality on how to do it and what are the consequences. Thank you.
Thanks, Peter. It reminds me the 5 milestones that the COREPER defined when the issue with visa waiver was discussed with the United States. Okay, now the floor is to Andreas.
Thank you. Well, I think that the directive does not comprehensively deal with the current patchwork of data protection rules in the law enforcement matters. The Article 59, for example, states that the existing instrument in the area should remain unaffected by the directive, while Article 61 says obliges the Commission to evaluate these prior acts within 3 years and make proposals for amendments where necessary. And international agreements are supposed to be amended within 5 years. We think that these periods of time, 3 years and 5 years, are much too long and significantly delay any possible improvements in the data protection framework. So both of these directions of this period should be by far shorter, and that's my brief statement on the already existing agreements.
Karsten.
Yeah, thanks. We, in principle, as Peter said, we support this and we welcome this provision. What is a bit, well, when I read it, when people read it, many thought, I guess, at least what they said is, so what happens with the EU, with those instruments that the EU has agreed to? I understand it's a directive, it's directed at member states, so it might not be, I mean, legally, it cannot cover agreements like PNR and TFTP and all those that have caused most discussion, but that certainly would also be something that the Commission would have to take up, and it would have to be ensured that these agreements then would also be checked, at least whether they're in line, and then if needed amended. So that's my only comment I would like to add to what my previous speakers had said already. Thanks.
Herke, you are the last of this series.
Well, I agree with everything that has been said. Maybe just one final consideration. When looking at the text, it says where necessary. As Diana also underlined, if it's in conformity with the data protection rules, there's no problem, of course. But who will decide whether it's necessary or not? I think some clarity should be provided there.
Now, I run rather fast to give the time to anyone in the public who want to raise some questions to our speakers. So we have 15 minutes. First round of questions. Anyone who is there? Okay. Okay. But I don't know.
We need a mic.
Either you come here or someone very kind will give you the microphone.
Is there a microphone?
Sí, okay. Attention, Herke, if you move, maybe it will be easier.
Thank you very much. A very interesting discussion. There is a lot of convergence, I think, in everything you say. I heard even my colleague Herke say that he agreed with everything that has been said. So spiciness is not there completely. Can I ask some question? One question. It's a lot about the directive itself, but what about the area in between so-called the directive and the regulation? For instance, processing of personal data by private companies in the area of law enforcement. Is that sufficiently regulated at the moment or under the proposal?
Other questions?
Daniel.
Daniel?
Oh, there is a micro coming there. Oh, even two.
Maybe will be stereo. Right.
Yeah. Daniel Drever, European Police Office. I have one question and one remark. The question is, I understood that the whole panel discussion was very much harmonized here. So it was, I heard often, I agree, but right at the beginning I heard something that I found interesting that Peter Michael said, that he said, well, trust is very important in law enforcement for the exchange of police information, and trust is provided by tailor-made instruments. So there I would like to have maybe some explanation what he meant. And then I heard later Herke saying, well, we still talk about the patchwork in the area of law enforcement. So is this question of belief, or I would like to have if it's possible, from the panelists some more background. And one point I would like just to make to Emilio, because you said that there are agreements in place within the European Union that the public or the parliament has no access to. If you look at the website of the European Police Office, you'll find a list. They're all our agreements, and you can have the wording of the agreement in PDF version for all the agreements that have been agreed by the Council. And we have no other agreements, only the ones that are agreed by the Council. Thank you.
Marie-Georges.
Bon, je crois que je suis tout à fait d'accord avec toutes les... in English. Sorry. I agree with all the missing point or the lower things that had been said. Now to be constructive. Is there a study, and I am looking to Michael, Article 29 group and everything, which makes the comparison between the national laws in this field and show where it is higher level. Why do I say that? When you harmonize in a field of human rights, you harmonize normally on a high level, which means at least the best level in a member state. So we need this instrument. Do we have it? Secondly, is there any project to evaluate Eurodac and VIS in this context? I don't think I saw that. But in my view, the proportionality in those instruments, especially regarding the number of fingerprints that you keep for years and years and years about strangers, while in EU we are fighting at each level of national level for having the lightest database, maybe we could have the idea of evaluate again those systems. Thirdly, how the citizen is going to understand the whole thing. I already asked the Commission, without any success, to have at least a website from which you have connections, links with all the different instruments and some explanation to know what they cover in practice with examples. There is no one portal about the whole thing. So this is really not democratic, to be accessible. The law should be accessible.
Thanks, Marie-Georges. Maybe we have the time now to ask our speaker to reply to all the very interesting questions that have been raised. To reply on the question of the site where all apparently the international agreements are published, I'm sorry to say that some of them are not published, and I'm not sure that the reason why they are not published are reasons that we can see, because the Parliament was not able to obtain this text. Okay. So, Peter?
All questions? To Hilke on the gap between the two areas. I never thought there was a gap. I also don't understand why people say there's a gap. Because the regulation says for private industry or for public authorities that there should be legal basis for processing it, or based on the contract and so on. If there is an obligation for private entities to contribute to law enforcement by processing this data, it's covered by the, let's say, the legal basis dealing with that. So there's the competence of doing that. The question then is which rules will apply, and then for me it's simple, it would be the regulation. The question of trust, I already said in my first contribution that the directive misses a lot of chances. One of the chances, some of the chances they missed is dealing with the issue of trust. If I transmit data to another country, I want to set up restriction how they may use it. You will find a provision for that in the framework decision. It's not in the directive. So trust is also based on the fact if I give something to you, there should be an understanding how you may use that data. And if I don't have any influence on that, I might not be able to give you all the trust which is needed. So the framework decision contained a lot of, I think, 3 articles dealing specifically with those issues which create trust and which are not back in the directive. The patchwork was already a critic stimulating to come to a comprehensive framework, but the only thing we can conclude now after we've seen what will be presented, there's still patchwork. Because there is a regulation, there is directive, there will be something else for the agencies, and there will be something else probably for Europol, EUROJUST, and other things. So the patchwork is still there. There was a question on how, is there a study whether the laws are harmonized? As far as I know, Marie-Georges, no. My comments made purely by my own experience in dealing with cases which involve member states, where I noticed the huge differences between member states. And we have European member states where data protection law is excluded officially during investigation to organized crime. If we exist with member states like that, it's not harmonized. And there was a question on can the citizens understand this? It depends on the education level of the citizen. That's a very dangerous answer I should give. But I'll give you an example. The supervisory authorities I work for have their own websites. We have their own explanation of the rights of the citizens, and we give the citizens standard letters they can use. But there are no visitors on the website creating that, because the core group we're interested about are the criminals. We're dealing with law enforcement. Unless it's a very clever criminal who has an organization and has a lawyer and interested in this issue. My experience is that criminals are not that interested what the police is processing about them. So the major public for law enforcement is not that interested. Thank you.
I really hope that the new perspective opened by the directive for collective actions also in this domain could be an interesting way to make citizens aware of their rights. Andreas.
Thank you. Regarding the point processing of private companies in the area of law enforcement, I tried to address this point in my introductory remark already. We think that rules on how to access data that is held by private actors need to be very clear and very strict, but it is true such rules mostly are absent from as well the directive as the regulation. So there is a clear gap that needs to be filled, and there needs to be clarified how with these data can be dealt and what may be done and what is not permissive. And similar strong rules are needed for transfers from law enforcement agencies to private sector actors. So in both directives, this gap needs to be closed and needs to be addressed. And the second point raised by Marie-Georges on how citizens will be able to understand the whole thing, I think the main point is individuals do have one right to data protection and to privacy. And therefore, this should be one legal instrument and not two, because then there could be a clear formulation by which exception to the right to data protection and privacy is necessary for this specific sector. And only these exceptions then need to be explained to the citizens, which would be much easier than to explain this whole set of things that are different from the regulation, where we now do not really know why this is the case. Thank you.
So, Karsten, you come from a country who now have 30 years since the census decision of the Bundesverfassungsgericht. So tell us.
Well, it's only 30 years, so I can briefly tell you about it. I would like to link that question to the remark made by the lady here in the front about is there a study on the different national laws. And I think and you refer to the Article 29 group, where one would think that they know most about it. And I mean, coordinating one of the subgroups, I have to confess that sometimes we start to discuss things and then we find out what we don't know about the laws of other member states, because there is no harmonization, and there are quite different rules applying, particularly in this field when it comes to the kind of a crossover between data protection and criminal procedure, where it gets very difficult and very messy. And I like to connect that to your point, Emilio, and that's why I was earlier referring to minimum harmonization. I think, or a high level of minimum harmonization, I'd like to say, because there it seems to be, I mean, we all certainly want to make sure that there's no lowering of any standards that we might have achieved under constitutional laws that we don't even know what the Czech Constitutional Court said on some points, or just to give you an example. So it seems to be a way to make sure that there's no lowering, and still at the same time to make sure that at least some principles, which are hopefully as high as possible, have to be complied by all. But I would agree, to come back to your questions, that a study would certainly be very desirable for all of us to help us understand what the actual situation is when it comes to data protection in the fields of criminal law.
I remind that the Herke question on the grey area where private company use data for security purpose remain unanswered. So the floor now to Herke.
Well, to answer the question of my colleague, yes, there is a gap. So I disagree with Peter. So we have a disagreement here. Because indeed there can be a legal basis, there can be an obligation there, but what about the limitation of the rights? That cannot be contained in the legal base. That should be based on the exception clause in the regulation, Article 21. You can restrict the right of access for law enforcement purposes. So then we move to the directive, you would say. But the directive only applies to authorities, competent authorities. So what about the private companies? They should be subject officially to a national law which restricts the regulation in order to foster what the competent authorities are doing. That's a gap from a legal point of view. And it's not addressed. The Drutsas report, which has not been mentioned so far, but contains a lot of good improvements to the proposal of the Commission, but tries to indeed bridge that. And also Jan Albrecht has done it in his report. Then the issue raised by Daniel about trust and tailor-made rules. I've heard a lot about tailor-made rules in the last years, you could say, in the whole discussion about a directive and a regulation. But there seems... 5 more minutes, thank you. But there seems to be a mix-up, a conceptual mix-up maybe, between tailor-made rules and legal certainty. I think trust is achieved by legal certainty. Trust is not necessarily achieved by tailor-made rules. I will explain a little bit. Because tailor-made rules can lead to a proliferation of rules. It can lead to over-regulation. That should not happen. That is not to the benefit of the individual, of the citizens. So it's not about tailor-made rules, it's about legal certainty. And I agree fully that, so we have the regulation with the basic principles. And for the law enforcement sector, as I said before, and it's also in Declaration 21 to the treaty, there might be specificities. But that concerns, for instance, a restriction of the right of access. And there you can create legal certainty for the area as such to lay it down in specific rules. But tailor-made rules sounds too much like, because everyone is special. It's not only law enforcement, but everyone thinks they are special. I'm pretty sure that Jan Albrecht is bombarded by people who think that they are very special in relation to data protection. The health sector, the banking sector, you name it. We are all very special. But still, if you discuss with them, the basic rules are the same. Then, the third point I want to pick up is the evaluation of Eurodac and VIS. I think the EDPS has in its report, or its comments on the proposals, has encouraged the inclusion of a provision which requires the legislator, let's say, to evaluate existing projects on their proportionality and necessity. So fine if you assess it in advance, but once the instrument, the measure of which is data protection intrusive, is in place, there should, after a period of time, be an evaluation, like is being done with the Data Retention Directive at EU level. And you see it works, although it's still there, and hopefully the court will declare it invalid, and then the status quo will change. But it leads to uncomfortableness. Law enforcement is moving, yeah, but we cannot prove it because it's, and we just need the data, etc. No, this is something which is accountability of authorities, which should be put in a law and should be obliged. They should be obliged to regularly evaluate on the basis of facts and political assessment of proportionality.
Now, some closing word of this very tough.
Yeah. Yes. Well, maybe to finish with another disagreement, because I think otherwise we are having been too nice with each other. I have to say I strongly disagree with the comments of Andreas and Herke as to the issue of the need to have everything under one instrument. And I think that all this idea I was saying is much better for the citizens to have everything under one instrument, because then it will be very easy to understand. I think it's a very simplistic way of thinking. I think what counts is the content of the rules, not the amount of rules you have. And proliferation is not bad if all the rules are good. They need to be consistent and they need to be according to the standards. But I think if you have very specific processing operations, like in my case, I'm talking about EUROJUST, Europol, etc., the citizen would have much more legal security by having very specific rules regulating what happens exactly in those databases, how the rights are exercised, etc., than by having one overarching instrument in which very general principles are put in place. So I strongly disagree with this point. I think we agree on the content as to the need to have very good rules and the need to have good procedures for the individuals, but I don't think this is achieved by having just one set of rules. And I think also, going back to the directive as such, that here we need to find a balance between, on one hand, willing to reach an excellent level of data protection, and I can guarantee you I fully support that. But at the same time, we need to be very realistic. We are talking about a sector in which so far we haven't achieved so much at EU level, in which we only have a framework decision with very limited scope and very limited provisions. And I think if we want to have something achieved, even if one step forward, even if it's not great, but it is already a step forward in harmonizing at EU level, I think it would be good to have something like this directive, even if we all agree it's a missed opportunity in a number of points. But I can guarantee you that to deal with national authorities, all of them dealing with different provisions, is quite difficult in practice. So having already a level playing field would be already a step forward. Thank you.
So we have discovered another disagreement between me and Diana, because I prefer have one single legal act, because we fight for years to have one legal base. We have one legal base. We have merged two different pillars in two different ways to decide. But this is for the future, and I think there we'll have a lot of occasion to discuss about this. So thanks to you all, and have a nice work for the following meetings.